Professor Mohan Gopal, Founder, Chair, National Court Management Systems Committee, Supreme Court of India. Aparna Chandra, Associate Professor of Law, NLSIU, Bangalore. And Rukmini S, Independent Data Journalist, Founder, Data for India, and author of an amazing book, Whole Numbers and Half Truths. Could we please all get on the stage here? We'll start with Apar. 20 minutes per speaker, okay. And then about 40 minutes of discussion. So, Apar, you first.
Use somebody's card. Thank you so much for inviting me here. And if I may please just request for everyone to settle down. So today's remarks draw from a public lecture which I gave a year back, which is called Digital Delhi. And it was on the occasion of the 37th Ramanathan Memorial Meeting organized by PUDR. It captured trends of digitization, science, and criminal investigation. And the larger question it posed for democratic rights. My objective today in these 20 minutes is to provide you an overview rather than looking at any specific instance or case more deeply as to what is the impact digitization is having on the criminal justice system using the violent incidents in Northeast Delhi about 3.5 years back. So Delhi especially likes to boast that it has a very high density of CCTVs. And in December 2021, our Chief Minister, Arvind Kejriwal, stated that with 4 megapixel resolution and night vision capabilities, these cameras are meant to increase the sense of security in the city. We are far ahead of London, New York, Singapore, and Paris, to the point there is no comparison. While we can forgive politicians for making such statements, there is a growing acceptance of digitization and technology and its impression which it conveys of providing security, which may not be actually there born from our day-to-day experience. Now, from a project development perspective for a poor country like India, what does it mean? Are these expenses justified? Or an inquiry which is more concerned with today's conference is that, does it offer us a chance at justice? Now, I believe some answers may be found not only looking at how digital technology is being assimilated today, but from where does it start? And this comes from the national broadband policy in 2004, around that time when penetration of broadband, internet, and personal computers, not smartphones because they weren't there at that point, was just 0.02%, 0.4%, and the personal computer was 0.8% compared to the national population. And around that same time, you also had 2 expert committees looking at criminal justice reform. The first one was the Malimat Committee, which gave its report in 2003 itself. And it stated and advocated for the use of technology, noting that in courts, if the existing challenges of crime are to be met effectively, not only the mindset of investigators needs to change, but they have to be trained in advanced technology. It went on to state, quote, it needs to develop and share intelligence tools and databases which would help investigation and prosecution of cases. Now, this is there in that report, which is then later on re-emphasized in the Madhav Menon's committee's report on the draft national policy on criminal justice, which again then has a much more detailed and a separate chapter which is titled as Electronic Surveillance and Use of Scientific Evidence. And it states, quote, developments in science and technology have both positive and negative implications for the crime and justice scenarios. S&T which is science and technology, can help solve more effectively the problems and challenges of crime, particularly those perpetrated with technological tools and devices. Now, what is to be noticed here is that the framing of technology seems to be principally from a opportunity and risk perspective. It is utilitarian in its very framing. The second thing which is to be noticed is that it is almost a form of determinism, which is that technology will inevitably be assimilated in the criminal justice system, and this will, in a way, deepen our challenges but also provide us opportunities. But I think this form of determinism or inevitability has come to characterize an illusion of technology and personal data advancing or improving prosecution and trial than it actually is. Now, this is also a feature of what I quite often like to speak about is the state allocating funds and also adopting these technologies. It's because there's a large number of private sector players who want these technologies to be offered to the state, who do and canvass for the use of these technologies. And here I'd like to refer to Manisha Sethi's book, Kafka Land, where she offers rich detail on how surveillance technologies came to be the centerpiece of a homeland security fair organized in Greater Noida, where a lot of good things start. She stated that the FICCI task force, right after the tragic Mumbai terror attacks in 2008, advocated for quote-unquote invasive technology. In fact, this report was authored then by Rajiv Chandrasekhar, who then went on to become the last Minister of State. In this report, it advocated for, and in quotes, totalizing surveillance technology, including centralized data systems, GIS, which means geographic mapping, analysis and reporting, and the ubiquitous CCTV camera. It stated, and this is a precursor to what it also asked for, was predictive policing technologies to prevent the commission of crimes. All of this makes it quite clear that there have been decadal processes for the advocacy of assimilation of technology in our criminal justice system, which not only comes from the state or expert committees, but also comes from the private sector through fairs, interactions with bureaucrats, as well as showing them these technologies which offer a certain degree of investigation efficiency. Now, I will return to Delhi. The lawlessness that occurred in Northeast Delhi between February 23rd and 26, 2020 serves as a case study on the role of what is called as digital policing and its role in criminal justice. As per a RTI answered by the Delhi police, it resulted in 53 deaths, 581 injuries, with 754 FIRs and 1,369 arrests. Delhi also has a very high tele-density of broadband connections, and the TRAI report states that there are about 2.8 connections per person, but that does not mean every person has a connection, okay? And this also means that when you're on your WhatsApp, when you have a smartphone in your pocket at all points in time, that flood of information which is gathered about you can at one point be used in a criminal prosecution to fit a framework or a structure which seeks to prosecute a person based on who they are. Does this actually end up happening? Yes, it does. And it has ended up happening in history again and again when there is data which is available and there's a lack of protection which is offered, how that data is gathered and how it is used. Again, the morbid example of the 1984 anti-Sikh pogrom in Delhi, where electoral risks were used to identify Sikh residents in localities for the purposes of participating in the Delhi Gurudwara elections, serve as a good instance why data protection is not only an elite concern about Google, Facebook, WhatsApp, but about limiting the power of the state and using that data or also collaborating in acts of violence. Now, coming to Northeast Delhi again, one of the databases which was in focus was the Vahan and the Sarthi database. The Vahan database is the database which is created for all vehicular registration, and the Sarthi database is there for driver's licenses. And the Ministry of Road Transport under Shri Mr. Nitin Gadkari wanted to reap additional revenue on the basis of these databases and sold it. And they did get money, good money, which is why we also get these calls every time our insurance is expiring for a car. but it has much more dangerous purposes, as was found when answering a question posed, when it was found that on February 26, 2020, that the Vahan database was being used to identify the religious identities of people and their properties. This was done whenever a vehicle was parked under somebody's house. You could just query the registration number and get to know if a Muslim or a Hindu family was staying under that premises. Now, this ultimately was stopped from sale by the Ministry of Road and Transport, but there was also further use of the Vahan and Sarthi databases. The Vahan and Sarthi databases, as per police investigation itself, have been used to identify the people who participated and were then prosecuted under these FIRs. This comes from a statement made by Mr. Amit Shah, the Union Home Minister, responding to a short duration discussion in the Lok Sabha on March 11, 2020, when he stated that, in quotes, through facial identification software, he's answering a question, how did you identify the people who were causing this violence? Through facial identification software, it starts the process of recognizing all the faces. This is software and it does not recognize religion and attire. We have put the voter ID card, driver's licenses, and all possible government data inside this software. Through it, more than 1,100 people have been arrested, out of which 300 are from Uttar Pradesh. Further substantiation is found in the annual report 2020 of the Delhi Police, which is no longer available on its website. It states that 945 CCTV footage and video recordings were obtained from multiple sources, including CCTV cameras installed on the roads, video recordings from smartphones, video footage obtained from media houses and other systems. These photographs were matched from multiple databases, which included Delhi Police criminal dossier photographs, other databases maintained. And ultimately it says, and this is in 2020, before ChatGPT and AI became a buzzword, Delhi Police also extensively used artificial intelligence-based technology for the enhancement of CCTV images for better identification of rioters. The e-Vahan database and the driver's license database were used for further identification. Now that we know how these databases are sometimes used, what is the effect? You have identified a potential rioter through this advanced piece of technology. You have arrested a person. What effect does it have on the prosecution of that person? And again here, we do have some evidence which has come through. The Delhi Police has stated that it quite often in its charge sheets uses this evidence, and even in bail hearings uses this evidence. And this evidence quite often results in the denial of liberty to the under trial. But it also uses other bases of evidence. This includes, and we heard about it when these riots were happening, drone footage, membership in WhatsApp groups, and isolated chats, which can be read in whichever way you want, where the phrase, "I'm a bounce" may mean a check bounce, rather than a colloquial phrase which means that I'm going to leave. It may include Google Map data and even conventional call data records. Now, what has been achieved by combing such granular digital evidence is revealed by two analyses. The first analysis is by Millennium Post, which reviewed 100 bail orders out of a total of 3,500 bails granted so far. This is a little old, so this analysis may be subject to further review and updation, but I think the trend will stand. And here I ask, especially academics who are here, to study the Northeast Delhi riots and also study how bails have been granted, what evidence has been furnished by the police, especially digital pieces of information, and what is its evaluation by the court. Because according to the Millennium Post, in at least 44 cases, the allegations against the accused were based on video evidence, out of which 32, the video footage did not stand up to basic judicial scrutiny, and the accused were granted bail. The second analysis is by Article 14. It's also a little old. And it states that in a series of recent cases, various Delhi courts have granted bail while holding the police responsible for, and these adjectives are not by me, this is as per or Article 14, these are as per the court orders, vague evidence and general allegations, shoddy probe, absolutely evasive, lackadaisical, callous, casual, farcical, poor, painful to see. Hence, all such advanced video recording, facial recognition, GIS mapping technologies which are sometimes presented to judges through PowerPoint presentations to give the appearance of objectivity or it being some form of science does not stand up to even basic scrutiny when trial courts have an inherent bias against granting bail in such allegations. Now, are these trends only limited to Delhi? No. On a national level, 2,919 crores from the Nirbhaya Fund, which was created in the horrific aftermath of the Delhi gang rape, was recommended by the Women and Child Development Ministry to be used for what is called as the Safe City Project, proposed by the Ministry of Home Affairs for CCTVs. Further, the Standing Committee on Home Affairs, in its periodic reports called Police Training, Modernization and Reforms, for instance, the report on February 10, 2022, states, MHA may incentivize states to leverage technologies like artificial intelligence and big data for policing. The proceedings of the committee make for interesting reading, with each city and state police boasting about its use of personal data or quote-unquote data lakes. Data lakes are essentially what a lake is, where they pour in all the data about a person and fish out whatever they want to take. And also, physical infrastructure is coming up in these cities to show out how the police is using more and more surveillance data through what is called as command and control rooms, which are having rows of LCD televisions which have live feeds. Or if you go to Hyderabad, I think one of the tallest buildings is the 20-story Command and Control Center. It is called the Command and Control Center, and the police there is quite proud about it, and even gives walking tours to people who may write about it. So it's not something which is deeply unpopular. It is not something which people feel is actually resulting in arbitrary searches, arbitrary arrests, and degrading our system of policing. It is actually popular, and this is why they're doing it, and this is a recognition we all need to have. I think some parts of that are also unearthed by the Lokniti CSDS report, which queried about 10,000 people and in 10 states and came to the view that even though 7 out of 10 people are afraid of legal prosecution for voicing their social, religious, and political views online, a vast majority of them support illegal surveillance software such as Pegasus on people who are not only politicians but lawyers and judges. Which makes me come to one or two things which I think are important for us to understand. The first thing is technology, when it is used, quite often will be used in an inverted manner to deepen imbalances of power if there are a lack of democratic safeguards, if our rule of law system is not safe. For instance, the Supreme Court's guidelines in Saifi Mohammed versus State of Himachal Pradesh for using CCTVs in police stations will not be implemented as the India Justice Report shows. However, CCTVs will be installed in mohalla lanes and will be used for policing us. And finally, the technology which is being used quite often today, just because the technology itself improves and its error rates become less, what is quite often said to us, does not mean that our criminal justice system will improve. For instance, the Delhi police is quite fond of saying that it started out with a 2% error rate in facial recognition and has now come to 80%. One of the cases which it cited is on the basis of a person wearing a yellow and blue jacket being part of a mob, which it calls a mob or a congregation, and then arrests him. And then it turns out another person was wearing an item of clothing with the same colors. But at the base of it will be a prejudice against a community. Finally, please excuse me for repeating these remarks, which I made 1.5 years ago. As Kanyabaram has quoted in Wages of Servitude, as well as accidentally this quote appears in the preface of the Justice Malimat Committee's report. Everything has been said already, but no one listens, so we must begin again. Thank you.
Thank you, Apar, for keeping to time. Rukmini, please.
Thank you. Don't worry if they are not very visible, they are more as a reminder for me. I want to start by, thank you for having me. My name is Rukmini. I'm a former data journalist, and I now run a public platform called Data for India. You will find it at dataforindia.com. The idea is to do something on the lines of our world in data, which is to try and expand the understanding of India through the data on socio-economic issues. Part of what we're trying to do is build legal data, and I'll try and come to that towards the end. But I want to start by acknowledging that the work that I have do now does not feed into a sort of direct or indirect really reforms of the criminal justice system or in terms of access to justice. What I do as work is to improve public understanding, so that includes public understanding of access to justice. But apart from work, and this is part of my earlier comment about bringing shoulders together, is an interest in how we can build public opinion and public understanding about issues around access to justice. So that's largely where I'm coming from. I also want to start by acknowledging the work of lawyers, many of whose work I build on. And when I was listening to Professor Vijay Raghavan, not just were all of those, was it all very insightful and moving, it also had deep resonances with reporting I've done and work I've seen, some of which I'll mention. In fact, there was an earlier comment about how these are almost patterns, similar instances. You'll see it, both of the instances that I've picked to talk about based on my own reporting have resonances and conversations that have already happened today. So really that's a striking aspect of this. So I want to reiterate that it is the lawyers who, particularly whose work in district courts, that I relied on, work that is difficult, work that is very poorly compensated, work that is often dangerous. It's their work that I'm building on. And another reminder from Professor Vijay Raghavan's work, which I hope that some of my reporting brings to my own work, is that I hate to use these words, but what work like that does is problematize data. There is no way that any of us can look at data sets around prison or around access to justice without thinking about the stories that were mentioned in the work that he does. So just want to start with some of those thoughts. This is Data for India. I'll come to it later. I encourage you all to have a look, as well as please give me feedback and comments. These are early days for us. So there are 4 broad things that I wanted to talk about today. And this builds on a combination of some of my reporting experiences as a field reporter who would often end up I was not a court reporter, but would sort of unwittingly, through someone mentioning something to me, end up reporting on some court cases. I think it also reflected a slightly more loosey-goosey time 10 plus years ago, when wandering into a court because you were interested in what was going on was something that happened much more easily, and I stumbled upon some of these stories in this way. Subsequently, I've done more focus on data journalism, so some of the work and some of the ideas then come from the thoughts that flow out of data and how that can shift public conversations around access to justice. I realize that I repeatedly talk about and think about public opinion, about public understanding, and I want to acknowledge right here and then going ahead that public opinion can be conservative, it can be fickle, it can be a very precarious and dangerous sort of access to rest on. And I acknowledge that while what my work does is to try and build it out better, to make it stronger, to make it perhaps more progressive. And then I want to end a little bit about talking about some of the work we are doing using data going forward, as well as some ideas for future work that build on some of the conversation around bringing shoulders together that we've had today. So just two sort of instances that I wanted to talk about from my reporting experiences, in which I certainly now, in hindsight especially, feel that good quantitative data at the time would have been truly valuable in taking what was a reported instance to perhaps a more fruitful direction. And the reason I have singled these out and think about them is because of the significant public conversation that happened around these, which has, whether this is a good place to stand on or not, there are certainly some issues that, in my experience, move people in a significant way when they read about it. Again, one of Professor Vijay Raghavan's examples about the reporting about the woman who had not been able to get bail. And then that drives thinking around, are these areas in which better data could shift what is already a area of public conversation or opinion that is ripe for shifting. So the one on bail, this was in 2011. A lawyer at HRLN mentioned a case to me that she was working on, and then I got to, I wore a black and white salwar kurta and accompanied her to court. This was in the Saket district court. This was a 19-year-old boy who had been accused of stealing 200 rupees from someone's wallet. He said it was his own wallet. He'd been denied bail once. He had maintained, and I'm not a lawyer, I'm going to use all the wrong words, most of which come from watching American TV, so they're all going to be wrong. But he had maintained that he was not guilty. So by the time I went to court, he had been in jail for 1 year without bail for this 200 rupees. And the bail bond was 10,000 rupees, which he did not have. So at that, I went to court to report on that there was this young man who had not got bail for a year because of this bail bond. The lawyer and he ended up having a discussion around it, and she explained to him that if he pleaded guilty, he would be convicted then and released immediately after. This all happened in like a whispered conversation while he was waiting, and then he did that, and that was it. That was the end of it. So I went to report on something else. This is what turned out. Of course, the thing I couldn't write about and which the lawyer was most upset about was that in the course of that 1 year in jail, he had clearly become addicted to drugs, which he was not in the beginning. She was, for her, that was the most upsetting part. But when we wrote about this, I think the amounts are also, they're like something out of a 1950s Hindi movie, 200 rupees and 10,000 rupees. It led to a lot of sort of outpouring of angst among people. And I think a lot of the time when we write about this stuff, there is a lot of judgment in readers depending on the nature of the crime. So again, when I talk about fickle public opinion, I don't think these are good pillars on which to rest reform, but this is as it stands. So because the amounts were so small, the man was young, Of course, he was Muslim. I wonder, you really have to wonder now if public opinion would still stand the same way. This felt like a different country in 2011. But because there was such outpouring about this, in hindsight, I certainly feel that it would have been one of the best times to be able to talk about data on bail conditions. Now, this man's story has stayed with me, and it is something that I've repeatedly wanted to find ways to do data-based reporting on, which is on bail conditions. I'll come to what we could potentially do about bail conditions in the end. But again, one of the reasons I'm bringing this up is repeatedly in legal forums, it strikes me that bail conditions is something that there is a lot of consensus around, that we could come together to build some sort of useful outcome. So I'll come back to it in the end. The second story, and again, two of the stories mentioned today, Professor Vijay Raghavan's as well as yours there, it's amazing to me how similar they are. This was a woman who, again, this was a lawyer I knew in Mumbai who was doing legal aid, and he told me that he was representing a woman, and when he met her, she had already been in jail for 10 years, accused of infanticide. She had spent one of those years in Thane Mental Hospital. It's really all of the same amazing similarities. Her case had not been heard once in the 10 years. She clearly had mental health issues. Again, the funny thing that ended up, not funny, well, in court, the judge was immediately ready to acquit, but she had nowhere to go immediately after she had developed. She was back in Baikala jail by then, not in the mental hospital. So the judge actually asked me if I could arrange somewhere for her to go by the next hearing. And then again, similar to what the professor said earlier, we had to speak to some NGOs. So it got, what is it? Not deferred. Adjourned, sorry, for a few weeks more until we could find somewhere for her to go, and then she was acquitted. So then too, again, all of the conditions, this was a woman with mental health issues, 10 years in jail without a hearing, again would have been one of those instances where if there was data on under trial population, as mentioned by Anup earlier, by reason, by cause, by number of hearings, it felt like it could have been a pivotal moment to take the conversation forward. And then I want to quickly talk about two instances where there is a lot of data, where the data has been at the forefront of the conversation, but the conversation has not moved forward. And I think I'll talk about 376 last, because it feeds into my next point about public opinion. So when Project 39A came out with a very detailed sort of survey and understanding and questions on the incarcerated population, the population on death row. We wrote about it, and there was, it was really striking to me that this was one of the instances where there was solid, substantial data which clearly showed the awful circumstances that had produced these situations, the level of poverty, the level of childhood neglect and abuse, and mental health issues. So it was one of those moments where it was striking to me how much it did not move public conversation. So when I think about resting reform on public opinion, that does come back to me as one of the reminders that it was striking to me how much of the response was, do you expect me to care about this, in short. None of this, I wouldn't change anything about it. I would want more funding for more such work. I would write about it in a heartbeat again. But certainly one of those examples where the data existed, the data was there, it could be shared, but what its effect on public conversation was something to think about. And the one about 376, I want to talk about a little bit. After the 2012 Delhi gang rape, because of the issues with the NCRB data, I tried to work with Delhi district court data by reading court judgments, and then saw what many have with much more rigorous methods established over the years, which is that parental criminalization of consensual relationships really was an enormous part of what was being put down as then IPC 376. Now, this was met with a lot of understanding and a lot of resonance in people's lives. I have to say it was also met with a lot of love by the MRA men's rights activist side, but we can safely ignore them. But there was a certain beginning of a conversation about let's think about consent, agency, not consent, sorry, let's think about consensual relationships, let's think about women's agency, let's think about whether or not to celebrate uncritically, declines or increases in numbers around IPC 376. But this really brings me to my next point about public opinion. Sorry, I'll include the public opinion here. The last 2-3 weeks of media discussion around the Calcutta murder, in a sense, have brought home to me the fact that one must be very humble about what work with data around legal issues and what it does to public opinion, how far it can go. When it goes far and when it doesn't are certainly things to think hard about. And the fact that the tone, tenor, nature of the conversation in the last few weeks has in some ways, it's been dispiriting that in discussions around statistics, forget the rest of the conversation, but in discussions around statistics, none of this really has fed into it. It didn't strike me that there is a renewed understanding of what IPC 376, now BNS, whatever, means, what large numbers can mean, what small numbers can mean, what the passing of these, greater restrictions on interreligious marriages can mean. So public opinion is not just fickle, it can also be conservative, but can also sometimes simply not move despite reporting and data existing. And, at least for me, it is important to be humble in the face of that and recognize that sometimes this can take reform only so far. Perhaps there is, the parts of the system that can be reformed or that should be reformed for this choose not to, and that is why we are seeing it this way. So that's one reminder. In all other ways, one could be proud of the work that has been done by this entire system around both 376 and POCSO, right? I mean, universally across this room, we would now know the rough share of overall cases that have to do with consensual relationships, but where it has fed or not fed into policy and public discourse is certainly worth thinking about. Just to take 5 minutes now to talk a little bit about what we are doing with our we're proposing to build out a legal vertical. And here we are building on the work of DDL. And really, I'll be happy to talk about this more perhaps at another forum with other people who want to do work using eCourts data, which is to, encourage you to use DDL data. Not because I know DDL in any other way, but because I know how much both the time and the cost of scraping data is such a deterrent to the work of so many researchers that we'd be happy to talk about our experiences using DDL data. Of course, there are many things, there are many issues, there are many caveats. We have spent months trying to figure out what can conceivably be done with this, because there are many things that you simply cannot do with the data. But to encourage more people to do this and sort of bring down the cost and time of scraping eCourts. So what we are doing, we hope to do, is very basic descriptive work around, a few broad IPC sections and maybe other laws as well, special laws as well, including the Negotiable Instruments Act. So this is not particularly, I don't think it feeds really into reform or into improving access to justice. For it is certainly areas of interest in which we are not currently able to answer with NCRB data because of the issues of, the deduplication exercise. So to me, it is valuable from a public understanding perspective, even just to say, what is the relative share of, IPC and negotiable instruments in the system? Among IPC, what do we see most often? We see, for example, these public disturbance, for example, is such a huge proportion of the cases that are in the system. That's valuable. But there is much more of value towards reform and access to justice that can be done from this, that can't be done from simple quantitative data, which is what we have. So if you imagine the first page, the metadata page, that's all you get multiplied by 80 million in the case of eCourts DDL data. However, we see great possibilities in the next step which is integrating the work of people working with LLMs with some of this. So just as an example, we are not able to pull bail conditions information from this data set, because what you'll get at most is whether bail has been given or not. But if you think of this as a list of yes, no's, there's bail and whether it was given or not, but those are all potentially clickable links that lead you to PDFs that an LLM could do more work on, we certainly see a future in which at least if a few important topics are taken up, and that was, my earlier question around, are there topics that we can come together that we really do feel are doable in terms of data, as well as have a genuine impact, as well as have some public resonance? And it certainly is my feeling that bail, whether bail conditions or not, is something that can be done. I know that NLU has done work on this. It's possible to do something at slightly greater scale, using perhaps a combination of DDL's data as well as work on LLMs that's particularly coming out of the Bangalore ecosystem, many of which are tools that are being built for-profit work, but these are replicable tools that can similarly be used to do other stuff like pattern recognition. So that's certainly a conversation worth beginning. Yeah, I'll end now. Thanks.
Yeah, can you get thank you, Rukmini. Certainly food for thought, especially about working with public opinion. And of course, a lot of us have a sense of deja vu looking at the Aparajita bill in Bengal. And it seems that nothing has changed, but it's like inoculation or a vaccination program, right? You have to keep at it and keep on improving. Aparna, please.
Thank you. Thank you so much for having me. I requested that I be allowed to go third so that Apar and Rukmini could do the heavy lifting. But no, also because they had mentioned that they'd be focusing on their specific areas, and I thought my own comments touch on both issues, so I wanted to sort of build on stuff that they've said. I should say I've not been here for the other sessions, so please do forgive me if what I'm saying is repetitive. I had about four and a half after listening to the two of you, but maybe 4.5 distinct but related points to make about the use of data, the datafication of decision making, and the digitification of the criminal justice process. I should say I do a lot of work with data. I have a book out recently which looks at the working of the Supreme Court through the lens of data, along with some other colleagues. We are looking at actually using LLMs for bail conditions. We should talk more. And so I come at this from as someone who works with data and who sees the potential of working with data. But I want to just sort of talk about some of the cautions that I've been sort of thinking about and keeping in my mind about data and its possibilities and its limits, right? So I mean, more of focusing on the limits than the possibilities. I'm saying this only to say that my work is with data, and so just because I'm talking with limits doesn't mean that I don't think that there is any value to data. It's just that I'm highlighting the limits. Just to clear the air on the importance of data itself, and including big data, of course, helps to move the conversation away from anecdotal, impressionistic accounts, which is a way in which, for the longest time, decision-making and policy-making, definitely within the legal system, has happened. Decision-making is very often by, for example, with the judicial system, is by judges who decide on internal policies based on their own experiences, and valuable as they are of course limited by the worldviews of judges and the social location and experiences that they have. Data, of course, allows one to, in some senses, step away, not in all senses, and I'll come to what the limitations are, but in some senses, step away from the immediacy of one's own experience and look at larger patterns, question one's own assumptions about what view one may have made up depending on one's own experiences. So I see a lot of value in dealing with data, and particularly data for policy reform. But And that's going to be the rest of my talk is about. Data, of course, is not objective, right? And just as science is not objective. Data, there is that myth of objectivity about data, particularly within the legal system. I've seen that in conversations I've had about my work with policymakers within the legal system, is that data starts serving as an anchor point very easily, right, in conversations. It's as if the moment I say, oh, but the data shows, and I can say anything else that follows, then that is taken as the anchor for the conversation going forward without querying that question of what the data is. So, but data, as we know, what we see and what we get out of a process of querying a particular phenomena will depend on what we choose to study, what we can study. Very often there are things that we can't study with the tools that we have, or with the tools of data particularly, what our methods are. And this morning I was having a conversation with Professor Mohan. Gopal, I don't know if you're going to be talking about the method, the census method question. Okay, so this bit I'm pushing off to him, but what consequences our methods of study will have on what we see, the inferences and the conclusions that we draw, all of this is of course very subjective. But like I said, the product of studying phenomena and putting particularly numbers to it, those numbers start acting as anchor points in conversations, particularly within the legal community, because there is this this sense of this aspiration towards objectivity, right, in the legal field, and therefore when there is this there's something more so definite as a number in front, that becomes a part of that conversation. As evidence, we know in the law of evidence this is treated as opinion evidence, but just as with scientific evidence, and again Project 39A's work in other fields has revealed this, but just as with very, very flawed subjective scientific evidence is treated not just as opinion but as fact very quickly, eliding the distinction that the evidence law makes. So also that's a question that happens very often with data, and particularly with the datafication of decision making. I want to give an example not from criminal justice but from reservations, from the conversation around reservations. Now, most of our reservation policies, but also our laws and even constitutional amendments get challenged in courts, and have been challenged, the detailed body of jurisprudence of the courts on this. And one thing that I think is very striking about how the Supreme Court adjudicates on many of the questions around reservations is by asking for data and querying the methods of having gotten that data in a way that it does not do for any other right? It puts the state to the strictest proof possible of the kind of data that the state has to base its reservation policies. I sometimes look at those judgments, and my students and I laugh along to say that we won't expect, for example, such a rigorous standard of method that the court expects, even from our master's level students. This is really the only place where a court puts the state to such strict proof. If you come to questions around personal liberty, or whether you should have, your right to privacy, what is the value of having a facial recognition technology and infringing on people's right to privacy, etc., there's a very, very limited burden that the state has, which is just to make a prima facie case. That might not be the legal standard, but in practice, that is the standard that the court generally says. We'll accept that there is a value to what you're doing as long as you can say that there is a value, right? So they fall on what's called the ipse dixit of the state. But when it comes to reservation policies, there is this idea that there should be data, there should be solid data, that data should be very, very strict and rigorous data. And if it is not available, then the policy is unconstitutional. So datafication then is doing two words, right? Two different things here. One is it is casting a burden, which is an unequal burden. And one has to therefore question, when people ask, but what is your data, right? That is not, that may be coming from a place of well, I wouldn't say ill intent, but of one should wonder where that is coming from as well. This is not to say we shouldn't have data for public policy, again, just to clarify. It is just to say that there is a ways in which the querying for data can often distort policies, or can distort what is possible in terms of policy making, which is the second point. Not everything can be datafied. There are many intangible benefits or the intangible consequences, things that cannot be studied through data for policies. Policies might be good to do even if their benefits cannot be captured in data points or in data points in the immediate context. And that kind of, the thrust towards datafication of decisions, we do not take decisions unless there is data and there is strong data of a particular sort, can then become the opposite of what I think the attempt here is, which is to stymie reform and to stymie change rather than to enable it. So all of this to say that I think there has to be some level of humility in terms of dealing with data and thinking about where the thrust for data is coming from, with what consequences. This gets me to then the question of big data and the allure of big data, along with the associated technologies of AI, ML, LLMs, etc. Now, obviously, we know, and I'm sure in this room don't need to say much about this, but the data. So to use this kind of data for decision making, and there is this impetus towards you harnessing these tools for decision making. Apar spoke about decision making at the policing and the investigative levels. There is that thrust towards doing this in the judicial system as well, in many parts of the world, definitely. To bring in again this sort of elusive myth of objectivity in decision making. But obviously the data, the artificial intelligence is not really intelligence. It's based on pre-existing human knowledge with all the limitations of human knowledge or human generated or human society. So it is backward looking in that sense. It is taking a reality and making a prediction based on that reality of what is going to happen in the future. And so if you're looking at bail conditions, for example, or predictive policing, the idea is that how people are and what they have been before and what networks and communities and societies and localities they are part of can determine something about their future conduct. That says something about how we perceive the human condition, the idea that we are somehow tied to our circumstances and we can never overcome our circumstances or overcome our past, that is particularly problematic. And it reminded me that this is not new. The technology of predictive policing and surveillance is new, but the idea of predictive policing and surveillance is very old. And for us, of course, the immediate, I mean, I'm sure this is a link that many of us make, but the immediate anchor point in terms of what is of predictive policing and surveillance is the Criminal Tribes Act, which is, I mean, amongst the various ways you can define the Criminal Tribes Act, is that it is a mechanism of predictive policing and surveillancing. If you are born in a particular tribe, you're presumed to be a criminal, a FIR is lodged against you at birth, and then you're going to be surveilled. The idea that you will never rise beyond the circumstances of your birth or the circumstances of your path, that has, I think, very, very deep consequences for what we think the criminal justice system is for. If reform is at all a value that we think of as part of the criminal justice system, what does it say if many of the moving parts of the criminal justice system, bail, investigation, under trial detention, sentencing, all of that is predicated on circumstances of the past, the individual or the social circumstances of a person. And I mean, as a linked point, what does that mean for the future? What does that mean for this person's future? Can they ever overcome that past? And a few years ago, I was looking up. There was this. A few years ago, there was a lot of conversation, and I'm forgetting what was the immediate impetus for it. A lot of conversation around having a national sex offenders registry, and that was actually started in 2018. The last few, I was looking at numbers, and the last data point from the government that I could find was in 2020, when they said that they have over 1 million entries in this national sex offenders registry. Now, I was looking at different state police websites to figure out what are these sex offenders registries, because different states, state police departments maintain their own registries. I do not know. I looked for this information. I couldn't find it. How all of that feeds into the National Sex Offenders Registry. So maybe that's a different body. But if you go on to the Madhya Pradesh police website and look at the Madhya Pradesh Sex Offenders Registry or the Haryana Sex Offenders Registry, you have a set of names with a range of details. Where details are available, it can range from this person has an FIR filed against a person in a certain set of, under a certain set of sections, without any conviction, trial is happening, or conviction has happened and the person has served their sentence. But all of that information is there and is available publicly. And what are the collateral consequences of this kind of information being made public and being available? Again, goes back to the question of, is there a possibility for a person to rise above their circumstances of their past, right? Even if we were to assume, which I'm not assuming for the moment, but even if we were to assume that every person on that list is actually guilty of the offense that they have been accused of, we've seen this kind of usage of data that is being put out in very often unintentionally or in good faith by courts, for example. So there are, Rukmini was talking about MRAs, men's rights activist groups, and we have to think of a better terminology for it, because, I mean, that the idea of them as sort of rights activists is rankling, but used to comb family court websites to get, make lists of women who filed 498A cases, and then, publicize it on different groups to say, here are women to avoid because they filed 498A cases. And so this kind of usage of data, the idea that that more data and more data out in the public and as much data as possible in the public is good and is an unalloyed good is something that, I mean, I don't think anyone takes that seriously in any kind of sophisticated, nuanced conversation, but there has been that push in the government, and so therefore that the sort of questioning of it and questioning of the consequences of it for some of our fundamentals of criminal justice, like what is punishment for, what is sentencing for, what is the criminal justice process for. I think those are serious conversations that we need to have. I will just end by saying that this imperative towards digitification of the criminal justice process and the datafication of the criminal justice process can then leave unattended some, the things that cannot be datafied or the things that cannot be very easily digitified. And I actually had the Safe City project in mind as well, because the Safe City project is spending all of these resources on putting up CCTVs in the public sphere, right, in the public square. And that is the focus of how do we make cities safe for women. We know through data that women are most unsafe at homes. And but this thrust towards doing the snazzy thing of putting in whatever is the snazzy thing, doing AI, ML, big data, datafication, facial recognition, so on and so forth, whatever it is that we are doing, this is in a space where the main and the root cause of violence against women is completely getting unaddressed, which is just to say that that kind of blinkered vision that this sort of tech utopianism, right, that technology will set us free, ends up doing is distorting many of our efforts within the criminal justice reform system. So therefore, this kind of all of this just to say that as much as we work with data and know the importance and the value of data in shifting conversations, in bringing patterns to bear on decisions, in making more robust decisions, this level of humility in what we are doing, how we are seeing things, how we are seeing things as opposed to some objective standard of reality that we are representing, and how the conversations around datafication, particularly with bringing in AI, ML, so on and so forth, can distort reform rather than strengthen it, is something that we should be wary of. I think I'm just about, okay. No, so I'm done. Thank you so much, and happy to take questions at the end.
Thank you very much, Aparna. Just couldn't help but think of how, in fact, this datafication of judiciary is allowing the Supreme Court to go out again and again and say that we are the largest court in the world, that we hear X thousand number of cases year on year. I think leaving the substantive part sort of unaddressed, in my personal opinion. The other thing I think which we can mention here along with digitification is the dashboardification of government data and the appification. So, but I'll pass the baton to Professor Mohan Gopal for his reflections. Thank you.
Thank you very much. I express my gratitude to Anup for inviting me here. I'm a great fan, like many of us are here, of Anup and Project 39 and their amazing work. And it's good to be amongst many old friends. I start with a caveat. I told Anup that when he said we have 4 panelists with 20 minutes each, I said that I've long since retired from T20. So I don't play anymore when it's just 20 minutes. I only play long form. So it takes 20 minutes for me to sort of get through the introductions. I mean, saying hello to people. And, so I speak like for a couple of hours. So Anup was very worried, but he still allowed me to come here on the assurance that I will not speak for more than 20 minutes. But I'm not capable anymore of speaking in shorthand. But I'll try to do that. I just want to make 4 points to stay within Anup's format. The first point I want to, and I'll focus only on the comments about data and the justice system, because that's where I've been working for over 2 decades, very closely. And I've had the privilege of seeing this sort of from the very beginning, how it has emerged. And what I remember is, in fact, this data for justice, I think, I can't say it's a knockoff, may not be consciously, but we had developed this tagline, knowledge for justice, for the National Judicial Academy. So this certainly goes well with that, data for justice. So that set me thinking. But certainly I saw that suddenly, after working on the judicial system for a long time, at the beginning of the millennium, after the 1991 liberalization started to produce a vocal and powerful and large middle class in India, there was a huge uproar from the middle class, the new middle class, about delays in courts. Criminal courts, civil courts, huge pressure. Now, all over the world, and I've had the privilege of working in many countries, everywhere in the world, in every country, the rich get justice. They don't even need a court system, but they get it in spite of the court system. It just comes in the way, increases their transaction costs, but they get justice. Nowhere in the world do the poor get justice. There's not a single country. Every country you find the jails are full of the wrong race, the wrong gender, the wrong class, everywhere, right? So, but the difference between India and other countries is that in these industrial countries, the middle class have a reasonable amount of access to justice. Not as good as the rich, not as bad as the poor. And so when a middle class emerges, there is a demand, a pressure on the government that there must be a reasonable amount of efficiency in the justice system and accountability. So I saw the judges actually physically feel the pressure of, because their own relatives and their family and their children are all saying, what kind of rubbish is this, what's that, Tariq pe Tariq, and all that kind of stuff. So then they started to say, we want to know what's going on. And then from Karnataka Justice Baruka, Aparna, please stop me when I'm at 20 minutes. She's used to stopping me for many years, so she'll do that. No, she'll stop me without a paper. So Justice Baruka and then Justice R.C. Chavan in Maharashtra, and the e-courts project and all that started to emerge. Now I'm starting to get into the long form. I won't, but a whole initiative emerged to bring in technology, bring in data to address the concerns of the middle class, right? And to some extent, it has worked. Sessions trials have become much quicker. The data is better. And for a long time, when we all worked in the National Judicial Academy, we focused a lot on that. And we can't say there's a direct cause-effect relationship, but for all the years we were there, we managed to keep the total backlog not getting into the 4 crores, not crossing from 3 crores to 4 crores. But after we all left, now it's jumped 4 crores and coming to 5 crores, which shows us that some kind of monitoring of data actually worked. So one small example, there's a challenge on how to formulate it, and I won't get into the details, but for example, we introduced a simple slogan called 5+0. Okay. 5+0 means every court in the country must have no cases older than 5 years in front of that court, for longer than 5 years. Then we said we must move from 5+0 to 4+0, 4+0 to 3+0, 2+0, and the ultimate standard was 1+0. For the first time in the history of the country, the court started to actually monitor how many cases are more than 5 years old across the board. Simple thing, right? There are many other examples like this that we were able to bring forward through the NCMS and other methods that started to have some effect in at least awareness of delays. Delays, very complex. Now you refer to the number of cases, they're very complex. You can't compare 60,000 traffic challan cases to 60 CBI cases. So we started to go into the complexity of that in great depths, and how do we have weighting of cases? And we put forward formulae for that. And so it's all very complex. But the first point I want to make is that data emerged into the judicial system to respond to the demand of the middle class that we want some reasonable access to justice. That was the first stage. The second stage that we saw was that data started to be used for injustice, for surveillance, for suppression. And when did that happen? When the 1991 reforms started to produce huge negative impacts on the masses of people, and there started to be unrest. So unions had to be suppressed, civil society had to be suppressed, people, all that you were describing, all these people have to be surveilled to see who was standing up against, who was going to dissent, who was going to protest. So China style, we'll soon get to social scores, right, in China, and your access to travel, your access to tickets, everything depends on your social score. So we are moving towards, so we move from data for justice for the middle class, first stage, to data for injustice. And we have not developed a counter to stop the use of data for injustice. That's where the census example comes in. Now, many people say, we want the census because we want castes to be counted, which has never happened after independence. The British colonialists used to count it. This is all humbug. What happened is, from the British times until today, the government has data on the population size of every caste. And on that basis, they decide what caste gets what entitlement to reservation. So in my state, in Kerala, for example, about 100 castes which have less than 2%, which are said to be less than 2% of the population, are put in one category and given a total of 3% reservation. So each one gets 0.003% reservation. On what basis? That the government is saying that your population of your caste is less than 2% of the population. How does the government say that? On what basis? How did the government argue in the EWS case that there is poverty amongst upper castes and this is the percentage? They are making that argument. So it is wrong to say that there is no data on caste, and the demand is that we have to now for the first time create data on caste and divide this country. There is data on caste, there always has been. But what really happened? What is the issue here? The issue here is a small switch was made by independent India's government on the methodology of collecting data on population. That's all that happened. What was that change? From 1951 until 1951, population of every community was counted on the only method used all over the world to estimate population of communities, which is 100% head count. A census basically is a methodology of counting. It's 100% head count. Independent India said, we will use 100% head count to count how many Hindus and Muslims there are, to show how Muslims are increasing in population and are a threat to Hindus. Now that Muslims are not increasing, they've stopped counting in 2021. And because that was just an instrument. So they said, okay, Muslims, Hindus, scheduled castes, scheduled tribes, religion we will count using 100% head count. But for the other castes, we will not use 100% head count. What did they do? They switched the methodology to applying the average growth rate of population of the state or the district or the province or the country to decide what the population is, let's say, of the Yadavs. Government knows what the Yadav population rate is. On what basis do they know it? They apply, for example, in Bihar or UP, the average growth rate of UP and Bihar to the 1931 census population of Yadavs and say this is the current population of Yadavs. What is the implication of that? The implication is that because the poorer populations have higher growth rate than the average growth rate, that's why the average is the average, you will suppress the actual population of the lower castes. And since the upper castes are more prosperous and their growth rate is less than the average, if you use the average, you'll get a higher population for the higher castes. So now today we have the population of the privileged castes inflated and the population of the lower castes deflated. This is all that we are demanding. We are demanding use the same methodology, 100% head count, to calculate the population of all communities, or don't count anyone's population. Don't count Muslim population, don't count Hindu population, don't count anyone's population. If you count anyone's population, count everyone's using 100% census. So this is an example, there are other examples also, of how data started to be used to maintain the oligarchy that rules India, to maintain injustice, to maintain repression, rather than, and in such subtle ways that this point is very little understood in this country, what's going on this demand for a caste census. It's simply a demand to use an honest method for enumerating the population of all the castes, or stop counting anyone's population. So the second stage was using data against the people rather than for the people in the counts. The third stage, the third problem, not stage. Now, okay, these are the two stages. We are at the second stage now. We do not know how to counter this, the use of data against us, because efficiency is being used to collect data, and that data is being used to attack our democracy, our freedom, our ability of, our ability to have honest information about our own population size. Many of the communities have not been counted for 93 years. So we don't know how to counter this. What is the problem? Next 2 points are on the problem. The problem is that we don't have a concept of justice. We don't really know. When we say data for justice, we don't know what we mean. There is no clarity at all. As some of the colleagues here know, for 20 years I've been focusing on this. What is justice? I want to have a monitorable, measurable definition of justice, because justice, social, economic, and political is the highest objective of the state. Many people go around with the name justice put before their names, then they merge. So even their family calls them Justice Uncle and Justice Chacha and so on, right? But if you ask them what justice means, they don't know. No one knows. So when we say for data for justice, it's high time we start to get anywhere in the world. We need to get more clarity about what is this end goal that we are trying to strive for, which we can use, because data is only a tool. So we need to use data to achieve justice, but we must have much clearer ideas of what are the operational goals that we are going for. And if we want to do that, then where we will end up is really to have to confront the issue that we will have to use data to promote social change in this country, social justice in this country, social revolution in this country. The main problem in this country is that power is in the hands of 4 communities. India is ruled by an oligarchy. In all sectors in this room, most of the people will belong to just 4 communities. Right? And everyone else is out. So we didn't fight against the British to hand over power to 4 communities to rule us. So we need data that can show the extent of the oligarchy in all these systems. There is injustice in the justice system because the justice system is in the hands of the oligarchy. Dr. Ambedkar in 1930 in the Round Table Conference demanded representative democracy on behalf of the depressed classes. He is the one, I'm borrowing from him, who used the word oligarchy. He said India will be ruled by an oligarchy after the British leave. And he said the counter to that is to have due and adequate representation of all communities. If you apply that to the Supreme Court, out of 34 judges, 8 judges will be scheduled caste and scheduled tribe. 20 judges will be non-Varna backward classes. 5 judges will be minorities. And just to ensure that they have some representation, 1 judge will be from a Savarna community. Now imagine the jurisprudence that will come from such a court. Right? So if we can generate data that will produce social change and promotes representative democracy, and how that is being suppressed, and how an oligarchy is ruling us and dominating every sector, academia, the media, all sections are ruled. We talk of the Russian oligarchy, but we have to expose the Indian oligarchy. Then I think we will be using data to move towards a more positive goal. But meanwhile, I think we have to focus, as all the presentations are focusing, as Anup is focusing in the area of death penalty, and I support that entirely. In the short term, what we must do in the face of these constraints, this is what you're doing, is to focus on getting data against injustice. So in specific areas, as all of you are doing wonderfully well, we have to expose injustice wherever it exists, using data. And so there is a huge, massive effort to use data for injustice, and we must counter that with another massive effort to use data against injustice. So these are the 4 sort of large points I thought I'll make. I'm not sure if I'm within my... I'm within. Thank you very much, because otherwise I'll have to face Anup after this. Thank you so much.
I think you were wrong on your own data about not doing T20s. Well, thank you. You've really, I think, ended this evening on the note that we all needed to, grounding it in justice, grounding it in human rights. And without further ado, a couple of things are left. I think my colleagues are going to distribute a couple of questions on each table. And then I'm going to invite Anup to sum up the 2 days first, while you think about the questions and also hear him somehow. And then Maya and Anup will come and discuss those questions with you. Isn't that the order? But before all of that, there is a Q&A, for which we do need the mics to be taken around the room. So, yeah, need hands, comments, reflections, but brevity. Yes. One there, over here. So maybe just start from the front. Medha, I think. Yeah, Medha.
Hi, I'm Medha, and I head the Fair Trial Program and Project 39A, and this is more of a reflection. So some of it is a carry forward from the previous session, but Aparna, you spoke about the methods of how data is coming, and I was wondering, Professor Raghavan in his previous session, he mentioned that there are two categories of people. One group here is of people who are interventionists. And we have the potential of, in some ways, generating data as well. And obviously, the larger goal is policy prescription and this group which is more of beneficiary of looking at data, making policy prescription. And I was coming more from a lens of how we are using data for implementation. And in the criminal justice system, I can quickly give 3 examples of where data or availability of data is a prerequisite for implementation. One is the UTRC, one is looking at the 436A, and the third is with the new introduction of a bail fund, how we are looking at who can be a beneficiary. So there are multiple points of intervention where availability of data is very, very beneficial for us to implement it. Should we be looking at using that lens to negotiate with state systems in normalizing data, in demonstrating the value of data to that one data entry operator or a senior jailer level of person? Why integrity of data matters? What value does it generate for the system? And what are the things we should be thinking about and having that conversation with the system? Because that gives us a legitimate point to bring in value of data in the everydayness, and so such that when we need data at a point where we need major intervention or major research, that data is already there. So that was, that was a reflection. And also then to say, what kind of capacity building do we imagine for people who are maintaining data? What kind of questions should one be asking from the system to say who is responsible for entry of data, who is responsible for understanding whether the data is being entered in the right form? That data entry operator who's putting things in the e-prison, do they understand the importance of missing out on one section and the implications it will have in generation of data? Who is extracting the data? Should we be asking for standard operating procedures? What is the data privacy regime that such data should be subject to? And I thought these are questions we haven't addressed in the...
Right. I'll come to you, sir. There in the Siddharth, right at the back. Just identify yourself, please. I think your mic is not working.
Sorry. Hi, I'm Siddharth. I am currently working at National Legal Services Authority, though here I am not representing NALSA right now. I have a larger, a broader question, not necessarily coming out of data, but coming from a place, what do we do once we have the data for something? And so the point being, in a Supreme Court case in Sonadar, data came on that there are almost around 5,500 people in prison who have been granted bail but not been released because of not meeting the bail conditions or the bail requirements. The point I'm trying to make is that what I've seen is that either the Supreme Court, all the constitutional courts, the High Courts, the Supreme Court, or any authority that we approach with any data point, they will throw a policy on your face, which at the face of it will look like a reform. So the question is, we also have to understand what actually is a reform. Now, what happened was that with this bail data, that so many people have not been released on bail, the Supreme Court came up with some very good ideas. For example, the judge will have to, the judge will have to communicate the bail order to the prison. But, I mean, sorry, I think I think I lost that point. I'm a bit underconfident, sorry.
I think what you're saying is essentially what is also the new scheme for bail bonds, how that has been designed in response to that.
So on this, thank you so much for reminding me. So now on this issue, the system came up with a scheme where the state will provide financial assistance to the prisoners who are unable to post bail. Now it's the prosecution which is functioning under the state, which is the arm of the state that is also opposing the bail in the court. And then it is the same system which will also apparently provide financial assistance. So to me, it is a policy madness. It is like it doesn't make any sense at all. Even if we are able to, get some people released out of that policy, still this policy legally does not make sense at all. And just a small point in terms of policy dumps. So prisons, I think, is an institution which has the largest number of external oversight bodies on it and is still the most opaque state institution. We have UTRCs, we have Board of Visitors, we have DLSAs having the prison legal aid clinic inside prison and so many things. On premature release, there was another data point that so many prisoners are eligible for premature release but are not being released. This was another case in the Supreme Court. Then Supreme Court again came up with a very wonderful policy that NIC will build a system wherein the e-prisons portal itself will show that in the next 3 months or 6 months, how many prisoners are going to get, how many convicts will be becoming eligible for premature release. But they don't understand the issues probably, or I don't know, of course they're smarter than me, they understand the issues, but I don't know why they don't do it. The thing with premature release is that the policy which is most favorable to the person should be applicable. They have data points on so the system will input data, the prisons will input the policies which are there without having any application of mind on the individual case. What if you have missed out on a policy that would have been applicable on me, but the inputs that the system made into the system according to which I'll become eligible has missed me out.
Right.
So
Thank you, Siddharth. Dr. Singh from BPR&D and then Chaitanya here in the front.
Thank you. Hi, good afternoon all. I am Dr. Amandeep Singh Kapoor. I am the IG at BPR&D. I am an IPS officer 2007 batch. So just as in the similar pattern of the last session, I stand up for police on certain points of the panel. This talk of 3 minutes around would be an ipse dixit of police versus ipse dixit of the forum. So bear with me. Policing is a dirty job, yes, as was reminded by Apar, but it is as thankful or as thankless as a social scavenger, or be it a lawyer, be it a doctor, or be it a policeman. So I stand here to do this dirty job for my organization. I have two contentions to fight. One is that you said that digital policing is mostly inverted policing. It seemed like that. And second one was that that was a valid concern, that most of the data, we have to look out for data doesn't go for injustice, collection of data. My contention is that when we do digital policing and bear our concerns, we shouldn't club every digital policing in the same brush, because as it with the normal policing, so is with the digital policing. There are two domains to them, or two ways of looking at that. One is policing done in good faith, and other is malicious prosecution, especially when there is gray zones and there's no light into it. Data protection, I'll give you, now I'll elaborate on that. Data Protection Act came. The previous version was a very tight act. We thought that it has a very wonderful consent paradigm. It should give a good hand to us. But it was withdrawn, to everybody's surprise. There were thoughts that maybe compliance cost was a factor, but the official version was that government wanted to keep it as a, featherlight legislation or soft approach to legislation. So when government does that, so for policy making is nothing but incorporating middle paths coming out from public. So when government does that with legislation, we don't call it inverted legislation. So similarly, the policing, when done with the intention where there is a good faith, shouldn't be called inverted policing. First. Second was a talk on data lakes, and why we should be worried about that. But my question is, can we avoid it in this age of Gati Shakti, or maybe Indian Datasets Program, data.gov.in, National Data Governance Policy? They're all datasets. How will we run from it? Wouldn't running from it would be an ostrich-light approach? So datasets existing everywhere doesn't irk anybody, but datasets existing in police irks many people. So my contention is that we should start learning at datasets of police also, and we are capable of introducing filters, and we are Gati Shakti or the datasets program has filtered. It isn't visible to anybody. Only authorized access has it. So we can't run away from data lakes. And third is, we are conversant with the facts. Like, we were thinking about asking the government that body-worn camera should be brought in. I think only US has one legislation about that. We don't have it. Maybe data protection rules, when they come up, will be able. So CCTVs, face recognition, body-worn cameras, we have told our units through BPR&D that wait, we'll let the things come out, we'll do it. Because it's a gray zone. It's not illegal, it may be unethical as of now. But let's wait, we'll decide on the legality as well as unethical part of it. And we are better placed amongst the whole data protection and personal privacy paradigm. Somewhere like US has some states only coming up, like California has a CCP or CPRA, an act on body-worn cameras, and on the other extreme is the EU's GDPR. Indian, mind it, we still have some data protection policy in place, or act in place. That is IT Act Section 43 and Section 43A, and the IT Act Reasonable Security Practice and Procedure in Sensitive Personal Data or Information Rules 2011. But if policing was that bad, or all policing was a malicious prosecution, has any policing been found, penal action been taken under this 43A that imposes a penalty of 5 crores? No. तो जब हम बच्चे थे तो हमें कहा था एक लकीर अगर छोटी हो, उसको एक लकीर को छोटा करना हो तो उसके ऊपर बड़ी लकीर खींच देनी चाहिए. तो if police is doing anything criminal, anything malicious, it's not my brief. Take them to the news, I am with you. But if we are doing something in gray area, why don't an army of lawyers who understand 43, I can vouch there are not more than 100 who understands the nuances of 43 or 43A or these IT rules. Because had it been that way, we would have got, so far we would have 100 units would have got the penal action initiated against them. So my request to this forum is that whenever there is a malicious prosecution, go for it. But when the areas are gray, and you understand that we are doing it for good faith, then our ipse dixit rests there, because that is how the judiciary is looking at it, and then you should have a soft approach to policing. Thank you.
Just last one, then we go to the panel from Chaitanya.
Hello, everyone. I'm Chaitanya. I'm a student of law at Campus Law Center. I'm in 3rd year. So my question pertains to a bigger picture of individual liberty, and it is to you, Apar sir, that we know that there are 2 channels of collecting data. One is overt data, and one example of that is Google Forms. Second is back channel data, which is browsing history leading to targeted ads. So what this does is that it translates into predictive analysis, right? Which is mostly done by private companies like Amazon, Facebook, Google, all those big companies, big data companies. Now, yesterday Mahesh sir talked about that a businessman will not hesitate to make a deal even with the bad government. What this does is it poses a risk of surveillance capitalism. Now my question is that, is there a mechanism apart from citizen awareness to curb this surveillance capitalism sort of thing?
Thank you. Yeah, so, yeah, go first. You just switch.
Okay. Thank you, Megha, for that question. And I'm going to take it along with Siddharth's prompt as well. And just use the UTRC example. I, in fact, wanted to use it in my main talk, then I thought I would run out of time. So thank you for giving me the opportunity. Because it, I think, illustrates some of the concerns that I have. So I was involved in some capacities in the UTRC, when the UTRC process was beginning in Delhi. And there was a court case where I had been asked to assist the court in looking at the implementation of 436A. This is a little bit prior to UTRC, and then some of that work fed into the UTRC in Delhi. And interestingly, we went to the prisons, and so of course the mandate is that the prison should be informing. There were rules that the Supreme Court, that the Delhi High Court had. There's a case where the Delhi High Court had passed an order saying prison should inform the court when someone is coming up for release under the 436A paradigm, so on and so forth. And so we were tasked with looking at why that's not happening. So we went to the prison and we asked them, okay, show us how you're sort of collecting this data, why aren't you providing this, etc. And we started following the trail of that data, and we found that, how is it that the prison gets to know what is it that a person is in for, right? There's Ajay sitting there, he was involved in some of those cases. How does the prison how does the prison know what a person is in for? When the court remands a person to custody, they send a jail warrant, right? And in that jail warrant, on that day, they add whatever is the section in the FIR generally is added there. And so this used to be, and now unless it's changed in the last 3-4 years, used to be a sheet of paper. And then that's stuck onto a notebook in Tihar, and that's how it's kept. And it's never changed. And in the course of investigation, sections will be added, sections will be dropped, a person will, charging will happen, they'll get discharged with some sections, they'll get, during the trial process, other different things will happen, but that's the document that they have. And we know, with due respect to Dr. Singh, we know that there is a tendency to overcharge in the FIR in order to cover all bases at a time when you don't really know where the case is going. So the information that the prison has, on the basis of which the entire process of 436A is happening, is based on data that is A, perhaps wrong, but B, completely outdated, right? And then the question, so you can build the best infrastructure on top of it, right? Get the best data entry operators, get the best standard operating procedures, make sure that they're not making any errors, do all of that. But they're fundamentally, where is that data coming from, right? So my concern with, therefore, all of this is I don't disagree with anything that you're saying. It is important to monitor how systems are working, and data can be a very useful product for it. My only concern is that we should constantly be querying what is this data, where is this data coming from, what is its source, authenticity, and not get enamored by it, where I see a lot of that the allure of data, so to speak, within the, at least definitely in the last 10-15 years that I've been active in this space. The moment so if you can get data, then that becomes the whole conversation point. So that was my general concern.
Apar, do you want to reflect?
Thanks. Short response to the gentleman who provided some perspective from the policing departments. Sir, I really respect your intervention here, as it takes a tremendous amount of, I would just say, forthrightness to interact in a forum which may not be as accommodative to your remarks, but maybe more towards mine. However, that will not change my views as to how the police force in India operates, and I'm not limiting it to the Delhi police. It's a structural issue of a post-colonial country on its path to democracy, where the police is principally used as an instrument of violence. That is my view, sir. I will maintain it. And it's also not only based on the books I've read, but my actual interaction with police officers, both for victims as well as for accused. It's born through years of practice. Now, how do they use technology? Quite often depends on the underlying structural prejudices which they quite often carry, sir, or whatever are the largest system incentives, which I think quite often do not factor in when technology is actually pushed towards challenging that power, both at an individual, departmental level as well. For instance, public accountability committees, which have been directed to be formed, which then allow us as individual citizens possibly to file complaints for illegally gathered evidence, have not been constituted. CCTVs, for instance, in Delhi police, 1 out of 3 police stations does not have it. The one which does have it possibly does not work. As per a CAG report, it does not have audio recording facility. So we do not know anything, and I'm not even saying the word bribes. Okay, but all of this does happen, sir. Let us consider that also as a perspective of how technology layers on top of that. And finally, sir, going back to what I was saying in terms of how technology may be used in a system which may actually illusionary to offer a mirage of certain reform but may not actually result in it. When we talk about body cams, for instance, sir, the body cam can also be switched off, can be switched on. Our principal experience with technology is captured by 2 words: server down. Right? And then it's on to the police officer how to position the body cam and their superior officers, and then for a court, possibly from my community or caste, to look at it. So, sir, even body cams by themselves will not offer that transparency or a CCTV. It will be the structural reforms which are quite often necessary to actually make our police forces also something which is better for police officers, giving how much do they work and what are their conditions. I speak from that perspective. And coming to your question, I really think that when you look at both how in the private sector and the public sector technologies are being used, and at its base there is a process of surveillance or the gathering of data. These are very strong incentives, both towards profit and power, and they need to be separated. And here, data protection is very important. I hope that the law which has been passed, it is not in effect, eventually becomes stronger in time. And also, there is a separation or a boundary between what is surveillance, in which data can be gathered without consent, and data which needs to be gathered with consent. But I think that these are things which rest upon greater civic literacy and people being made to realize that a lot of their rights, which they want in terms of representation or in terms of welfare benefits, are dependent on this data-fied interaction which people have quite often. And I think that will take some time. It will be a decadal process. So there is some hope there, but I think it will rest on civic literacy and educating us how we can align the gathering of personal data more towards our constitutional goals.
Yes, to agree very much with Apar and with a couple of examples, I think the challenge in the initial part of our experience, the laws were progressive in large part, and we wanted to ensure compliance with the laws. But now the laws are becoming regressive. So we need to look not only at implementation, but we need to question the operation and impact of those regressive laws and gather data on that. And of course, there is even the data we now have. So if you take SC/ST Atrocities Act, and you take crimes in India produced by your organization, 2022 is the latest crime in India report. You have Atrocities Act, total number of cases around 57,000. Not Atrocities Act plus IPC. Now that, as noted there, those involve cases of violence by SC against SC on SC violence as well in IPC, versus Atrocities Act is only non-SC against SC. There are only 4,700 cases in the entire country, which is purely under the Atrocities Act. Now, who is responsible for it? I can give you, I'll end with that actual example. A colleague I work with in Kerala was speaking about the injustice of intouchability and so on. Very powerful, he's a Sanskrit scholar, very powerful speaker. Purely academic talk, nothing else other than pure analysis. Someone sent him a death threat saying, "I'll kill you," to a Dalit, knowing he's well known to be a Dalit. So I accompanied him to the SCST Commission, and the SCST Commission chairman instructed the police to file a case. We said the Atrocities Act had been violated, and IPC as well. The police persistently refuses to register a case under the Atrocities Act. First they said there is no crime at all. Then when the commission the commission is only recommendatory, got strong, then they said it's under the IPC. But even though the commission told them you're threatening a Dalit that he will be killed, and you're saying the Atrocities Act doesn't apply. Right? So there's no data on any of this. So where we are is we are at a primitive dinosaur age in terms of data from the perspective of social justice and injustice. And that's where I think we need to make progress. We need much more data than simply some very rough, bald figures. We want to know how many complaints are you receiving. Why don't you put online every complaint received in every police station in India online, and give us data on that, in which case the complaint I made would have been recorded as a complaint that the atrocities had been violated. This is how it's done in other countries. And then ask why is it not being registered? Why is an FIR not being registered? And there are opposite examples of when powerful people are affected, how FIRs are registered in double time and implemented so fast with lightning speed. Right? So I think data is a tool. It is now being used for increasingly to hide injustice and to provide justification, and we need to look at the structure and design of data in much greater detail to expose the failures of the system and not just hide them. Thank you.
Yeah, just do we have Anup time? Maya time for 5? One more question round? Yeah, up to me. Yeah, I think Professor Mohan, Gopal, do you want to comment on the policy pandemonium being caused by data? One arm of the state catches, lets them rot in jails or under trials, and the other arm says, no, I'll post the bail for it. That question by a colleague from...
Yes, I think in short answer, it is the data that 75% of the, I think according to this 2022 numbers, we have 434,302 under trials in jail. It's more than 70% of the total people are under trial, and it's a crime. Most of them are very poor people, if not all of them. So that data, but we have some data on that, but very superficial data. But that data is, even that little data is producing some response driven by a few people, a few judges, a handful of people. It's not the whole system operating. There is a Justice Madan Lokur who finds out that there are people still in jail who've been acquitted years ago and they're still kept in jail. And he drives some change. And there are individuals who are driving. The system is not driving change. The system doesn't care. So I think I don't see it as contradictory. I think it's a weak attempt. Nalsar is a good example, number of initiatives coming from Nalsar to try to ameliorate to some extent the injustice. But the data is not even showing us the tip of the iceberg of injustice.
Yeah, thank you. Yeah, please.
And
then Ajay, and then, yeah.
I'm Tasneem, I'm an independent legal researcher. I was really struck by the exchange between Apar and Mr. Kapoor, and I think it engenders two questions. One is a question about motivations, and the other is a question about definitions. So yesterday there was one of the researchers, she stood up and said, she works with in the juvenile justice space, and she stood up and said, we've got a lot of data, we're afraid to put some of it out because we don't know how it will be used. How is that different from turning on a body cam and turning off a body cam? The difference is motivations, right? There is an assumption that her motivations are good. There is an assumption that cops' motivations are bad. But
keeping that aside, we need to be questioning motivations when we think about data. Motivations are very relevant, and this ties in with my earlier point about the legitimacy of data. The second is definitional, and here I go to Mohan's point, which is what does justice mean, right? Does justice involve civil liberties? Does justice also involve crime control? So Apar is interested in civil liberties, that aspect of justice. Maybe Dr. Kapoor is interested in the crime control aspect.
Dr. Singh.
Dr. Singh. So it's, I mean, so I think it's, this is not an us versus them. I think this is a question about how we think about the legitimacy of data, how we think about defining constituent elements of data points, and how we think about identifying motivations behind the collection and dissemination of data points. If we think about the legitimacy of data using some of these parameters, I don't think we will be having the kind of disagreement that we just had, because honestly, they don't really disagree with each other. Data is important. Data is what data does.
I disagree. I disagree in principle. I disagree in principle against video gathering when you don't have underlying legal frameworks and safeguards and our experience with the police. I disagree.
I agree.
Yes.
But
it's healthy to have disagreements. There should not be pressure to agree to a consensus till there is a clarity in disagreement as well. So please respect my disagreement as well.
I do. You're calling for standards, and that nobody can disagree with that.
Okay, permission. No, I think your point is well taken, but I think we have to make a distinction between publicly gathered data and privately gathered data. So what we want to say is that publicly gathered data, the police data, body cameras by the police, they're accountable to me. But if Aparna gathers data, she says, okay, I've gathered data voluntarily through my own effort, and then she worries about the responsibility and the impact of that. She's not accountable to me as a citizen for that. So I think the public data must be made available. Public data must be gathered extensively, and we need data about injustice. We cannot, see, there's no them and us. I'm the son of a police officer, right? There's no them and us. But ultimately, we want to live in a country with liberty, with equality, with dignity, right? And anyone who violates that should be held accountable, wearing the uniform of the state. They should not violate that. But crime control is a very complex issue. I don't think we are doing an effective job of that. That's a separate debate. But in the name of crime control, you cannot keep hundreds of thousands of poor people in jail indefinitely for years and years. Why are there no middle class or rich people in jail? Is it because they're all good people and never commit crimes?
yes.
Yes, of course. Of course. Of course.
Hi, I'm Ajay. I need to have two comments because Professor Aparna Chandra has raised a very important issue.
Just brief.
Yes. So the error in data from the prison, what is coming with the warrant, jail warrants, and the courts. So in HPC during the COVID period, a large number of HPCs recommended the release. The responsibility was given to the prison officials.
The high-powered committee set up.
To the prison official, high-powered committee was constituted by the Supreme Court to release the under trials or the 14 categories and other. So large number of responsibility was given to the prison officials. So under the HPC, certain guidelines were given, the sections. So the prison didn't have the updated sections subsequent to filing of charge sheet. So this data created a miscarriage of their application was not forwarded, and later on delayed the release of those persons or the process by the judiciary. This is one aspect. The second is the impact. I think Professor Chandra is forgot that she was given a very big responsibility when the Honorable Delhi High Court passed the judgment in my case for personal bond release or people who have received the bail, to see the impact in the district court, how they are implementing this order. After the judge is passing the order, within a week he has to ensure and check whether this person is released or not, and then if he is not released, to conduct the impact assessment. So that was another data thing, and later on it became like the judge was mandated to maintain a register in the district court, and some courts I am still told that Ajay Verma register. So that's some comments which was because there's data correction from the courts immediately, and still I am finding it even the dismissal order, because once we are helping the prisoners under trials, the dismissal order doesn't go to the jail. This is sometimes only the bail granted order will go, and then they will see that whatever modifications. So there are a lot of things which is mismanagement. Perhaps collectively we can work on those areas and then see impact. Thank you.
The last final comment from the audience. Yeah.
Hi, I'm Afreen, and I'm a lawyer. I keep morphing into a couple of other things as and when. So I just have two days of very rigorous discussions around data and justice. To somebody like me, numbers, they really bog my brain. It just stops. So justice, I completely understand. So I have two reflections, a very heartful request at that. One is Rukmini was mentioning about your experiences. I was a HR lawyer, so I think we understand what we are talking about. So the non-numerical aspects, and we have talked quite a bit for the last 2 days, how to capture certain things, say for example, in MTP matters, Aparna is here, I was one of the interviewees you guys did in your research. Say for example, I have an MTP matter, I come back, it is a fetus, the reporter sits with me, I guide her through, this is what we want, this is what the judge said, and this is what it meant, and it is a fetus, but somehow it just does not register and it is recorded as a baby when the report is out. So whenever the data is being gathered, not necessarily relates to criminal justice, but at some point when it does, are we going to count baby killing or just MTP? Because there's a very... So when we are looking at the apps or digitization, how we should be perhaps looking at how we go about this, how to record what just transpires and the intangible aspects. The second is considering every agreement and disagreement we've had over the video camera and all other kind of data storing, as much as I disagree with all of it principally, even if the state wins at it and it is going to record the data, then am I going to need, will I have the access when I need it? Say for example, if I have a client and they are just put, criminal matter, 21 cases, something they're not even party to, but I do not get access to the record of those 21 cases. And they just languish in the prisons for so long just because we don't have the access to those details, and is why we haven't been able to prove to the court that we are very much eligible for bail because there's only one case and this is exactly this and all the other cases are false. Or will I have access to all the camera recordings, not in the way that we have today, not in the quality that we have today. What Apar was mentioning about the color turban, like 2 or 3 more people with the same color. So somehow, and this is where we agree, because, and perhaps the intention that ma'am was talking there. So whenever, if at all there is going to be a data record in advancement of criminal justice, will I get it at the very beginning of the start of criminal justice? Because we can be talking about big data, we can be talking about numbers and policy, but when I'm talking about criminal justice, I really am looking at that one person who is languishing in the prison for so long. And as a criminal lawyer, that becomes very difficult. Everything else then just remains numbers to me. So yeah, those were the things that I would like to look at going forward. Thank you.
Thank you. Thank you. No, I think the point is taken that while we are supposedly using data to demystify the justice system, I think we also need to demystify the word data itself and not limit it to just numbers. I think Professor Mohan Gopal said data is knowledge. I suppose it is knowledge which has been the horrible word, but the bapoti or the inheritance of the Savarnas for centuries. And I think how do we ensure that that gets massified, democratized, while at the same time protecting civil liberties. Now only we have to close at 5, otherwise they'll switch the lights off. But before that, I would call Anup to sum up the 2 days, and then Maya also please join Anup and do a little bit of sharing of feedback. The panelists can stay on stage, they can go off stage, it's only up to you. Yeah. Thank you very much.
Good evening, everyone. And having told everyone for 2 days to stick to their time, I will stick to 5 minutes that I have. And just very quick reflections on the 2 days. And some of the main things that stood out for me was that in this conversation for data for justice, I think what we really need to think about is what are the strategies for change that we all may adopt in our areas of work. And that strategy for change has to, and given that we're all functioning in a system of extremely limited resources, institutional resources, monetary resources, HR resources, that prioritization has to become very important as to for what purposes are we using data. Be it child rights, be it environmental justice, be it bail. We need to have a strategy for what is that strategy for change. And within that strategy for change, data can have a role, it may not have a role. Some elements of it might have a role for data. And we live in a country where you saw massive outpouring of outrage when Jairaj and Benix were killed by the police in Sathankulam in Thoothukudi, right? But we also live in the very same country that celebrated and honored the police who killed the 4 accused in Hyderabad, right? We live in that country of contrast. And so even when working on something like that, we have to understand what will trigger change in what aspect. And in that, we cannot ignore the public. It's not just about, and one of the important stakeholders is the public discourse on it. And this is not to say that every change is driven only by public discourse, but I just felt that that's an important element of strategy to keep in mind as to what narratives need to be built to trigger what kind of change. And I think a big takeaway for me also was that state as the sole generator and supplier of data needs to be challenged, right? That it then leads to all sorts of problems of what questions are getting asked and what questions are not getting asked. And if we fall into that trap of we're only going to rely on state data, and how do we enlarge this idea of the legitimacy of data beyond just state generated data, we are not going to be asking these difficult questions that we need to ask of the system, and we're just going to stay within the rules of the data that is being generated. And of course, a huge takeaway was, is there a need to bring in questions of institutional capacity into our rights strategy? Right? That if we are all engaged in the rights discourse, as we rightly must be, and towards criminal justice, how do we incorporate strategies of institutional capacity into this discourse? Or do we think that that's not our burden? And I'm not offering an answer here, but if institutional capacity is the vehicle through which rights protections are to be delivered, how do we, as many individuals who work in this space, engage with that question of institutional capacity? So, and in terms of and in terms of thinking of political strategy, and I want to emphasize the point that all of us struggle to imagine the work that we do as broader political strategy. It's not something that we do, and when I say political strategy, I mean in a broader sense. I don't mean it only in terms of party politics. I mean in terms of larger political strategy. Is that a space in which we need to get into more broadly? And how do we get into it? Because we seem comfortable to a large extent to argue on basis of principles, and now to a larger degree on the basis of empirical evidence. But I wonder that whether there is, beyond principles and evidence, there is also political strategy. And whether we need to start investing more effort into that direction, and what is a role for data there, right? And in terms of, and the last point I want to make is data for storytelling. Right? We need to tell better stories. We need to invest in better storytelling of different kinds. It could be a data-heavy piece, it could be an emotional piece, it could be a documentary, but we need to find data that can also be translated into better storytelling. And what that storytelling is, and what is the role for that storytelling in triggering various points of change is something for all of us to explore in our respective spaces. So with that, I am out of my 5 minutes. So thank you very much to everyone. And this is my last opportunity to thank everyone for coming. Really appreciate those of you who took the time out this weekend to be with us, to come from different parts of the country and your busy schedules. Huge thanks to Valay and Maya for inviting us into partnering with them on this, and from NLU Delhi itself, from my colleagues Bharti and Prerna for the effort that they've put, but also to Pulkit, the teaching assistant and research assistant with me, for the incredible amount of work that they have put in over the last few weeks, and also the student volunteers from NLU Delhi who were here the last couple of days. So thank you everyone, and I hope this is something that will continue, and looking forward to seeing you all at the next edition. Thank you.
Good afternoon, ladies and gentlemen. Also, did you want another minute of my 3 minutes? Okay. Okay. First of all, thank you so much for being here. This whole weekend thing is really an imposition, so we're very grateful. And data is not Netflix, okay? It's really not Netflix. So that you gave up Netflix for us is very nice. It's very good of you. And I want to also thank Anup and his team, and Pulkit, who I mentioned right in the beginning, and also Arshi and, I just went, Arshi, Nida, and Bharat, who have been standing silently at the back, but taking very surveillance pictures of all of you. So you should watch yourselves. Before we close, I also would like to say a couple of things. I think that the things that I heard a lot of articulation of was the challenges. And I'm not going to go through all of the challenges, but the fact that we believe that we can do it wherever we are, whether we are in the police or whether we are in the prisons or whether we are generating data from the government or generating data privately or generating it as a cottage industry or generating a mass. The fact that we are here and that we think that this is valuable is great encouragement for people like us who at the IJR are right. We keep on thinking that we are still right at the beginning and producing only one resource of the many that can join together in a river to create a river that will finally try to change public discourse and try to change the practice of criminal justice towards civil liberties with the protection of civil liberties, and join it all together in a stream eventually on the ground. That's why I loved what Professor Mohan Gopal said, which was, let's prioritize creating using data that goes towards exposing injustice. I think that's something to take away from here, and we can do this collaboratively, especially since there is a humongous amount of data that is being generated, and technology is adding to both the fear as well as the possibilities of what we can do. Now, how do we harness this? One of the great things about technology is that it is creating the ability to speed up and with ease extract that data. We work with extracting that data, and it is becoming easier. At the same time, everything has got two sides to it. I cannot understand for the life of me why the state which has the most amount of data and the most granular amount of data, should be so defensive about accessing it, putting firewalls, putting captchas, making it easy. Somebody told me that they don't want it commercialized. But if they're going, eventually the commerce is, and the need for profit has, we have seen again and again, overtaken all our efforts. So why are we resisting this and not producing data, not putting out data which is really granular, which can help us to both prevent crime, assist in the rehabilitation of people, and do so much more for the safety and security of the country. Besides this accent on surveillance, which is driving us all crazy and deflecting us from the real purpose of collecting data. Which brings me, it forces me actually to think about RTI. There has not been that much mention of RTI except to pull out your hair that it's not being given, the information is not being given. We all over here know that the RTI has got two sections which are really important. One is Section 4 and Section 8. Section 4 forces the government and all its agencies to give proactive disclosure. Now, this is not a favor to everybody. Don't forget that the Right to Information Act is the child of fundamental rights. It is not an administrative remedy. And as such, a violation of rights is there when it is not given and so many obstacles are put in the way of it. It is forcing us as requesters of what should be Section 4 rights, it is forcing us to become from citizens into subjects, into petitioners, into pleaders, into givers of 10 rupees and 50 rupees and going back and forth to get the information which is collected only for public purposes and collected by people who are public servants and who are paid by us. So I would urge you to think of yourselves think of us as citizens who are really being denied a right rather than giving information which should in any case be there. I'm sorry, I did go on a bit about it because RTI is so important to me. Now, I am asked to ask you several questions, which we will go around very, very quickly because I am told that we must finish within time. Some of the questions are on your tables. What are the data-related challenges in the criminal justice system that you would like to focus on? Now, this is not going to be a commentary, okay? You've got to give me 2 words. What do you want to focus on? You might already be focusing on it. You might be wanting to focus on it. Think. What are the 2 perspectives that interested you most about the colloquium? That is to help us to think about what we can do next, on your next weekend. What elements would you like us to focus on in the next edition? Again, nobody is allowed more than 2 words, and I'm good at this. Anup, do you want to start? Okay. Those who have not spoken first get privileged. Here? Any 2 words about any of the 3 subjects? What are the data-related challenges that you want to focus on? What are the 2 perspectives that interested you most during the colloquium? What elements would you like us, as the organizers, to focus on in the next edition? I might add that any of you can do the next edition. We'd be happy to come and be on that side. Pooja?
Access to do more research.
On?
No, I mean like just the fact that we are not, the fact that we concentrated only on
2 words. 4 words in your case. Go on.
research permissions.
Research permission. Permission for research. Christoph.
More collaboration to avoid duplicate work.
more collaboration to avoid duplication. Thank you. I'm just pointing randomly. Please put your hand up. Yes.
Regarding the second question about two perspectives, one would be AI-related tools to help the judiciary, and the second perspective is the sort of tension I saw between state authorities and non-state authorities over data generation and use.
Thank you. I hope my colleagues are taking all this down. You had your hand up, sir. You can still be sir, even if you're a student.
On the first point, I think publication of raw data by officials that can be helpful for private research.
You'd like to focus on that?
Yeah.
Okay.
And the perspective I liked was the addition of economics and the institutional part than the rights approach.
Yes, I think that was an accent that I left out. Marrying economics and the work we do on criminal justice system to see whether that can be leveraged to create a conversation. Aparna?
The data against injustice point, I think just what all avenues does that open up? That's the uppermost thought in my mind.
Okay, you're processing, but if you have anything, please say.
First question, the challenge I am most interested in right now is state manipulation of data points.
State manipulation of data. Okay. Would you like to say something? Yeah.
Capacity building. So practical techniques for capacity building, what does that mean? Because I feel like those are the two words that came up a lot, that this is a problem of capacities. So how can we build capacities like that?
Within the state or everywhere?
Within the state.
Within the state.
What can we do? Because we are using the data. Obviously, the data is not great. We don't love it. So how can we help them build capacities?
Changing curriculum.
Curriculum, training, incentivization of data collection.
Right.
Making a business case for data collection, all of that.
Okay, thank you. Yes?
Intention to disseminate data from the states, especially.
Whose intention? Ours or the states?
The states.
The state must have an intention to disseminate data widely.
Yeah.
Widely. Thank you. So I'm sorry, I was going this way, but I'll go this way. Okay, I am showing a right bias. After you, we will go there.
So in a way, sort of combining
Sana, speak up.
1 and 3, I would look at witness protection as a big area where, sort of, let's say, looks at both victim rights and also addresses many of the pendency issues in the under trial question that we've been dealing with. That is a big area of what we call missing data area. And this is one of the areas that I would really like to sort of focus on and like to see some of that here also in the IJR.
Okay. Anybody at that table before we move the mic? Okay. Yes, sir.
On the third question, I think...
Please identify yourself.
Oh, yeah, I'm Abhineet. I'm a student in NLU Delhi.
Yeah.
On the third question, I think the methodologies we use to process data, especially when the data is constrained, and how that constraint affects those methodologies, I think that would be interesting.
Okay. Do you have a particular methodology in mind?
Nothing. I just wanted to know more about how we sort of, how the methodologies change in face of constraint.
Okay. Okay. Thank you.
Hello, my name is Bhavik Kaushik. I'm an LLM student in NLU Delhi. My point is regarding the third question. So I would like you or anybody else in this room to focus on simplifying the data so that we can encourage the narrative of importance of data in the common discourse between the common citizens of the country. Because most of us in this room are privileged. There's not many a chance that we will ever face or go to jail or something. But the people who are really going to jail are still outside this campus. They're still looking for it. And we have to work for them.
So simplifying data and disseminating it in ways that will be understood by the general public. Is that the way?
Yes.
Thank you. Prerna. I will come to the centrist bias in a minute. Go ahead.
In relation to the three questions,
Sarah,
in relation to the first question, I think identification of the criminal justice philosophy that India is following, because the philosophy will determine a lot of things, and to balance retribution and rehabilitation. Yeah. In relation to the second question, I like the CJS model, the model we were shown yesterday, input, inflow, whatever. And
right.
What was missing? Alternative paths to justice. I don't know whether that's a discussion to be had. Lastly, with the last question, I'd like us to see, we've heard a lot about the prison situation. I'd like to see an application of Mandela rules in prison reform in this country. Thank you.
Thanks. I believe that in theory it is incorporated, but in theory, okay? And when you were talking about alternate ways of looking at criminal justice, were you thinking of informal community-based, remedies outside the formal system?
Many countries in this 21st century are looking at non-custodial sentences and drug rehabilitation orders.
Yeah, I believe the new BNSS has got it. Very limited, yeah. And we also have the Probation of Offenders Act and so on. Please, yeah.
So in terms of elements that I would like to see in the next edition, maybe more focus on qualitative data and using it for storytelling.
Thank you.
In terms of the first part, the data-related challenges that I would like to focus on is in terms of collecting data on victims to develop victim advocacy and victim rights.
Okay. That table, yes. Avinash, Ajay.
I'm starting. I'll start my.
Apandeep, yes, yourself, madam.
So I'm Neti, I'm from the Migration and Asylum Project. So I've sort of married the first and the third questions together. I think that, capacity building is extremely important and we should delve into that question a little more, but also the question of who is accountable for bad data, who is doing an external audit maybe, is that something we can consider of the data that is being produced? We question its legitimacy, we know that it isn't, we know it isn't good quality data, it is the only data we have to work with, but is there a way that someone can be made accountable for it? Is there an external audit that can be done?
Thank you. Thank you. Amandeep, that might be something that you'd like to consider given the situation that given the position that you have, and we're trying to develop a data policy. So
yes,
is accountability an element of that?
Yeah, for that purpose also, I like
two words. Yeah.
Best case scenarios and worst case scenarios. Somebody can come and present them across the ecosystem. Secondly, maybe I'd like to hear something how prosecution department is sharing the data, because we face problems with not only the persons under trials, but person of the sort of Lawrence Bishnoi also. So criminals, how their data is being put up by prosecution, the courts deny the bails.
Right.
So that somebody next time from the prosecution can come and share that.
Thank you. Ajay?
Well, my view would be the more collaboration, coming with a collective strategy, and then people like us, advocates, can use the data in courts.
Avinash? Avinash is our data czar.
Data standards for governments because we face a lot of gaps in trying to use the data to answer questions. So data standards for the data that government puts out and how it puts out.
Data standards and data standardization?
Yes, that too.
Also, thank you. Anybody else at the table?
I think for the point, I'll answer for point 2. I think it was really interesting to think about data as a questioning point and not an anchoring point, and the subjectivity of understanding of data, at least in the context of the Indian Evidence Act. And I would like to open it up to more situations where we explore the subjectivity of data and why it should drive narratives and should not be just looked at as numbers.
Thank you. As we speed along, we have to speed along. Please.
Quickly.
I'm sorry,
yes.
It's a bit unfair, but what to do?
That's okay. So my name is Sanuti, and I work with an NGO based in Chennai called Tulir. And I think for me, the first question about the challenge that I think Swagata and Anant, both of them spoke about, which is the juvenile justice element, like young people who are in conflict with law and the data around them. It's currently a black hole. So in the guise of confidentiality and privacy, are we then missing out on opportunities of monitoring and checking for what happens when there's a procedural lapse there? And I think that's one challenge that we would want to work on.
Thank you. The lady next door? You're good? Yeah.
I don't know if this has been already covered, but linguistic diversification, because a lot of knowledge output out there is in English. And I think for public dissemination, if we can linguistically look at that, how without compromising the quality, the main crux of the argument, we can just diversify what we are speaking of in linguistically.
Thank you. Vidya, the lady in the beautiful sari.
Thank you. I think what's really important and what we've noticed over the years is we have to get this tribe to increase. The tribe of civil society interested in using data optimally and in terms of advocacy, because I think that's really important.
Thank you. Thank you. Yes?
I think my biggest challenge in data gathering has been exceptions to the RTI Act, particularly on national security, which also pervades through other institutions in the criminal justice system. So that's something I'd like to see addressed. For next editions, again, I'll echo what Anup said in his closing remarks, which is to have a political vision and a political strategy surrounding data instead of viewing it as something that speaks for itself.
Thank you. Rukmini?
Thank you. My two words are pragmatism but completeness. So how to be pragmatic about what we do with the data while still ensuring that it's statistically clean and largely complete.
Thank you. Anybody at that table?
To the last question of what to do next for the next edition, something around data governance, speaking to the point of datafication, like whose onus is it to make sure that data is not being misused or is being used properly. So something around that would be great.
Thank you. The ladies in black.
Yeah, so maybe a little more focus on the Digital Data Protection Act. I just wanted to know and explore more about this act.
Apar is here. Get hold of him. Nobody at that table?
I was really interested to know how the discrepancy in different state official data and versus what the independent research data showed. So that really opened a lot of doors, because since I'm a law student, I didn't know much about it. So this was a new interesting thing for me.
The trick is to disbelieve both and then to start again. Okay, the next.
I would like to focus on data legitimacy issues.
Data?
Legitimacy issues.
Legitimacy issues, okay. And the last table. Meeran. Meeran? The whole audience is waiting. Okay, okay, thank you.
Sort of tying all questions together, I think perhaps in the next edition we can look at more at, I know we keep trying to involve more state actors, but a collaboration can possibly help us understand what are the pain points in the system. For example, what are the problems they face while collecting data, while storing it, data protection, and sort of understanding what stops them from making interlinkages between various systems. So looking at integration, and perhaps that can help us use a functionality perspective and understanding how to not just collect data, but also looking at what are the solutions then towards ensuring that the data that's already existing can be utilized better.
Thank you. Last word.
So just to add on to that, maybe looking at developing a framework for collection of data that exists outside of the state system. So data that all of us have in civil society, lawyers, and data that lawyers and paralegals have, how can we kind of integrate that and use that and developing a framework for it?
Thank you. Well, all of you are on a list. There is availability of information about yourselves as well as connectivity, right? So if you're talking collaboration, if you're talking future, if we're talking about doing things together, all the opportunity exists, but I think the initiative is now on that side of the room rather than this side of the room. So thank you very much from Anup, and thank you very much from the IJR, and we sign out. Thanks.
Thank you.
Aren't we supposed to shake hands?